Hi, everyone. This is Dave Mongello here with local attorney Jim Ostrowski. He is smiling today. He doesn't have his Buffalo shirt on today, so we can't wisecrack for that.
Yeah, my wife bought me this shirt, so don't mock it.
We're going to give you, we have two big cases going on with the Second Amendment. One regarding Benjamin Wassall. He was charged with one of them black gun violations. I think they called it an assault gun for some reason. And then we had another case against the Sullivan Act, was the first pistol permit law written by criminals to protect criminals in New York State, that all of us gun rights people were forced to get this permit put in place by a criminal senator way back when. Is there a spot for my head there? No, I think I'm good.
You look okay.
All right. So the case we're going to talk about today is Ben Wassall. There's some updates with that. It's currently in the 4th Department right now. There's links to this case. We'll put it on this video later on, and then links to it. And then there's been some movement on this. These are probably two of the biggest Second Amendment cases right now, and we are just trying to garner some support. So please donate whatever you can, because time costs money. And Jim's putting a lot of his own time, a lot of his own money into these cases, to protect our rights. And we're going to go through some brief history of this case and these cases, especially Wassall's here, Ben Wassall's, to explain what's been going on. In your table of contents on the case here says, Jim, that the judgment should be reversed because the Attorney General had no apparent authority to prosecute the case.
Well, that's not our strongest issue. But that's an issue that I put in there. They've subsequently claimed that there is a letter that authorized that. I'm looking at that.
Okay.
But let me just back up a bit and say that I want to give a sort of procedural update, because people were planning to go to Rochester on January 17th. Now, that was and is the date scheduled for oral argument. It's most likely going to change. So let me explain how that worked. I filed a 55-page brief on behalf of Ben, which raised a lot of issues, which we can get into. They then responded with and this is the Attorney General's office. It's like, the largest law firm in the state with virtually unlimited resources.
So our tax dollars paid for this.
Oh, absolutely. Right. So this is 71 pages. This is their brief. And I just posted this on Facebook. And I think what we'll do is we'll add it to the GoFundMe page, because I think our brief is on there. So that wasn't enough, 71 pages. I think the page limit of the court is 70 pages. And so then I got tipped off that they're making a motion. They're not thrilled with their Second Amendment argument, because we did challenge the SAFE Act on Second Amendment grounds. So they've proposed to the court to amend and add, a lengthy section on the Second Amendment, which also has exhibits on it too. Then that would make the total brief 83 pages. So at that point, I have to respond. If that's granted, I have 14 days to respond, to do a reply brief on an 83-page brief, which is not easy, but it's doable. That's what we do. So they also asked the court to put the date off, and I suspect, since it's the state of New York asking the state of New York court to do something, they probably will be granted. So we're on standby on January 17th. I know a lot of people wanted to come, and they're still invited to come. Just real quick on that, court space is limited. You're welcome to come, even if you have to stand out in the hallway, because it's still a statement of support for Ben Wassall. But absolutely be on your best behavior here. This is not village court. This is a high state appellate court, and I don't want to give anybody legal advice, but they're not big on buttons, this, that, and the other thing. You may say you have a First Amendment right, but if the court deputy says take that off, the priority is not to interfere with this appeal. You can vindicate your First Amendment rights on another occasion. So that's the update on that. Now, on the Second Amendment appeal, that's of the pistol permit law, the Sullivan Act. We expect that to be argued in February, but I check the court daily. That's the U.S. Court of Appeals for the Second Circuit. That's the one you see on TV on Law and Order all the time in front of the court steps, 40 Foley Square, downtown Manhattan. We don't have a date on that. As soon as we do, I'm going to blast that out because we want a lot of people to go down to New York throughout the state, attend that. We'll have a rally outside. Imagine a pro-Second Amendment rally in the heart of Manhattan, and you can imagine how much fun that's going to be. And I don't mean that ironically. It's going to be a lot of fun. So that's where we stand with calendars. So if you want to get into, both these cases are funded on a shoestring basis. Crowdfunding, we call it. There's really no other way to do it. There's no sugar daddy here. There's no Koch brothers. There's no foundation. It's just me and your generous donations. And as I announced yesterday, I'm not going to do these cases in the future. I'm going to hand it off to somebody else who have the privilege of doing all this work. I will finish these cases to the bitter end as far as they go, including the New York Court of Appeals, Supreme Court, as far as we need to go, depending on how the court below rules. But I'm not going to take any more Second Amendment cases. I frankly have had enough.
Well, let's hit on some points of the appeal, and then you were talking about the pages, but I think they wrote this for a blind guy. Look at the size of the print. It's like huge.
Yeah.
It's just like,
well,
they can make the pages. Look at even the line spacing.
Well, I think it's my brief also.
I thought it was interesting, but you want
it to be readable because these. I guess mine is 12-point font and theirs is 14.
Yeah, but on the point of
good of you to notice those details.
Yeah, it's not going to win anything. It says the court erred in instructing the jury in Ben's case. I thought that was interesting. The court failed to adequately respond to the jury note concerning the SAFE Act. What went on there that you felt was?
Well, I can't summarize a 53-page brief, but here's the bottom line. The SAFE Act is so complicated and confusing that a very good judge in this case was unable to clearly explain it to the jury. And there's one critical point there, and I'm not going to reach for the brief and try to find the page, but basically out of the presence of the jury, they're talking about responding to questions from the jury, of which there were numerous questions. And the judge actually said, I'm not going to read the statute to him, it's too confusing. And I said, okay, well, that's due process. So we put in a due process claim because the statute's too confusing. But basically, not to get too technical, but there was an issue about whether the grandfather clause applied to Ben's case, and Ben's attorney, I think, argued that it did. And in an attempt, when there was a request to explain that, the judge basically explained the law in such a way that the jury only had one choice but to convict. And we pointed out that after the final response to the jury's final note, they came back in like 10 minutes with a conviction. So we're challenging the jury charges, the due process, equal protection.
So it basically said the law is void for vagueness in itself because the term assault weapon is very vague.
Yeah.
And the evidence supporting what was going on here. And then on top of that, you have something on defense counsel.
Because I had to raise the issue of ineffective assistance of counsel because so many of the issues I found in reviewing the record were not objected to at the time. So unfortunately, that means I have to ask the court to hear those issues on its interest of justice jurisdiction. We're getting a little technical here, but also to say that to ask the court to find that the counsel was ineffective for not making those objections.
And for those of you, if you know anybody sitting on a jury, please refer to this. There's a poster right above Jim's head there, that Fully Informed Jury Association. If you know anybody serving on a jury, if you're sitting on a jury, please go to that FIJA website. You'll understand your true powers of protecting other fellow human beings. Serving on a jury is a patriotic duty in itself. You can actually use your heart to protect other people in society. Just a quick point on there. But.
One of the other key points we made here is that the prosecution witnesses, one after another, has stated their opinion about the law, and that's totally inappropriate. And in fact, the judge, in summarizing the testimony, the judge would refer back to the testimony of so-and-so. And I argued that, well, that testimony involved legal opinions on the law. So the judge sort of ratified those legal opinions of certain witnesses, like police officers who are not experts in the law. and furthermore, their legal opinions on the law were actually incorrect in many ways. So it was like error compounded by error, wrapped inside other errors, and wound, wrapped up in a bow of error. It was error upon error here. And I think that's why the Attorney General's office asked for 2 30-day extensions to answer, and now they're asking for another extension to supplement the Second Amendment portion of their brief. So I think
here we got a guy, Ben Wassel, that the court in the law was totally wrong. He was charged, obviously, found guilty, and here the government is trying to support their wrong acts and using your money to fund the wrong act by the government to keep this guy charged as a criminal. This is what everyday people in society are up against when something like this happens.
Right. You have maybe a couple grand in the bank, or you're borrowing from relatives to pay, or you have a donation box for your attorneys. And all along, you're up against a government with unlimited resources.
The state.
Unlimited
state.
Yeah,
yes.
I mean, they're on salary, and they'll spend as much time on it as they possibly can, and your lawyer has to have a law practice to make a living. Fortunately, I had a fair amount of time to get this done, so I think everybody's happy with our brief, and I'll work very hard on the reply brief. Then go up to Albany, and we have to work on the oral argument, which is a very tricky thing because you only get 10 minutes up there, and you really got to summarize your key points and be ready for questions from the court.
So what we'll do is I'll post updates, links to the FundMe page we have on this video. Also links to the documents if you want to read and go through it. It's very interesting when you start reading the stuff and the arguments they're making. As a typical normal human being, you can see that what they're doing is wrong. But we need your support more than anything else. Thanks for listening. Anything else you want to?
No, if feel free to read my brief because I write in plain English. Some of the issues can be kind of complicated, but I think you'll understand exactly what I'm saying. And then I haven't totally analyze their brief. If anybody wants to analyze it and pass along ideas, I'll certainly, we'll what's the word? Crowdsource it. Yeah, that's the word.
I was just admiring your very nice shirt today. And
well, thanks. I'll tell Amy you said hello, and stop over any time, Dave.
All right.
You want to talk real quick about the Second Amendment challenge, the Second Circuit challenge?
So the Second Circuit is the one, the Sullivan Act, correct?
Yeah, Sullivan Act. Now we got 2 amicus curiae briefs filed.
What is amicus curiae?
It means friend of the court. So you can ask for permission to file. Well, actually, I can send it. I don't care what arguments. I know we're right, so you can argue till the cows.
So these were sent in by people supporting
pro-gun control. One was
people.
The Bloomberg group.
Yeah.
And I can't remember their name. They have kind of an odd name for their group.
Yeah.
Actually, I thought was funny. And then the other group was the Gabby Giffords Gun Foundation, the congresswoman who was shot. So,
so the key
I'll
elements.
be responding to not only the Attorney General's brief. The Attorney General also represents the opposing party in this one, coincidentally. And 2 amicus curiae briefs, and again, I'll have like 10 minutes to do it. And the Second Circuit has generally not been too friendly to the Second Amendment, but the interesting thing is, I checked the other day, there's 1 Trump judge up there already, and there's 2 in the pipeline, and they're moving pretty quickly because, of course, the Senate controls the well, the Republicans control the Senate, still do. So it's possible we might, what would be really interesting, and I have no control over this whatsoever, obviously, is to have one Trump judge on the panel of three, possibly two Trump judges.
Yeah, do you want to hit on the basis when Jim found this Sullivan Act out? He looked into it. He found out what about the judges? They were actually judging. They were committing ethical violations.
Well,
regarding to your
this gets into the weeds, so to speak. But
this is when you apply for a permit.
In my pistol permit, the pistol permit application process, which I have handled in a few counties, have a few cases going on. It's not really clear, they have a judge handling it, but I argued in the federal lawsuit that, well, what we did is let me be blunt, we sued the judges for money damages. So of course the other side said judges are immune from money damages. Well, they are. So I responded that they're not acting as judges. And when judges aren't acting as judges, they're not immune from money damages. And we went back and forth. And I made the point that, well, if they're judges, how come they're engaging in ex parte communications, which means communications without all the parties present. So oddly enough, a somewhat obscure New York State ethics panel of judges, but an official state body, said that these pistol permit judges are not supposed to have to comply with the code of ethics.
Because the only reason why a judge is supposed to be there is for a trial or a court, and yet they're signing our permits right in the bottom there. So it's just,
they can't have ex parte communications anymore, and they're supposed to have a prosecutor there, because as I argued in numerous cases, state and federal, they were sort of acting like prosecutors, judges, the jury. They were doing ex parte communications. So I know the sense of the legal establishment towards this lawsuit that we filed is, oh, there goes Ostrowski again, out on the fringe. And no, actually, our legal analysis has been vindicated by the state of New York. And by the way, I'm not William Kunstler for the libertarian cause. I really generally don't mix politics in the law, and my law, I just won a false arrest ruling from Judge McCarthy in federal court the other day against the city of Buffalo. I'm by the book. I usually win my cases, I think, if you look at my record over a long period of time. No, everything we file is solidly legally grounded, and we hope to win at the proper level.
Yeah, you really.
We'll go all